Good morning. Are you Nasir Brown?
I'm not here today showing special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity Nasir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just.
And right out of the gate, we've got a classic courtroom curveball. I'm not here today. This is a tactic often tied to pseudo-legal theories where defendants try to separate themselves from their legal identity. But here's the reality. Courts don't play along with that distinction.
Said, because you've now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation.
This is where things start to spiral. The defendant is using confusing, almost scripted language, something judges hear more often than you'd think. But legally, none of this changes one simple requirement. The court needs to confirm who you are. No identity, no progress.
From February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
Is this been upset?
Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay. So here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30.
And there it is. The judge draws a hard line. This isn't about wordplay anymore. It's about cooperation. Refusing to identify yourself can quickly escalate into being held in custody. Question for you. Do you think the defendant realizes how fast this could go south?
3 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
And just like that, the strategy collapses. One yes resets everything. The judge now proceeds normally, because legally, identity has been established. All that earlier resistance, it bought him nothing.
You understand what I'm saying, sir?
Not blind.
You'll oblige.
Blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication.
The subject matter jurisdiction challenge, another commonly used phrase in these situations. But here's the key. Courts automatically have jurisdiction over criminal matters like this. Simply saying the words doesn't make the case disappear. It just delays the inevitable.
Today, you know exactly what I'm talking about.
Yes.
So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk.
And now the gravity of the situation hits. These are serious charges, felony-level offenses involving violence and a child. At this point, the courtroom isn't about clever phrasing. It's about legal consequences. So ask yourself, should the focus have been on strategy or on securing a strong defense from the start?